welcome to Chai Chat with Lavina. Something that is very uncomfortable is to write a will, because that makes you think about your life ending. But then, just a small thing like writing a will or giving an understanding to your family members as to what happens after you leave is something that will secure a lot for the lives of people who you love and you leave behind. And that's exactly that we wanted to discuss in this legal hour. We at Chai Chat have committed to a legal show every 4 weeks or so, and therefore for that we have been running a promo with Darshan Azad, who has a very unique combination. First of all, he's a solicitor as well as an advocate, isn't it, Darshan?
Yes, that's correct. I have a high rights of audience and I can represent clients in the higher courts, such as the High Court, Court of Appeal.
Brilliant. So we have been running a promo with Darshan about wills, probate and trust. And there's another episode that we want to do eventually, but this is the first thing that we want to talk about today. So before, could I just welcome you now at this stage?
Yeah, thank you very much.
Thank you. I already
Welcome to the
asked
office. Lovely seeing you again here.
Thank you, Darshan. Thank you very much. And thank you for doing this for us and our audience. So, as I said, will is a very uncomfortable document to think about when you're alive.
It is.
Isn't it? But tell me what exactly it is and how important it is.
A will is a testamentary document that records your wishes and what you want to occur with the assets and liabilities that you leave behind when you pass away. Now, the benefit of a will is predominantly that you have control of what you want to do with your assets and liabilities, and you can stipulate those in that testamentary document. Should you fail to leave a will, the law then prescribes what should happen to your estate, which includes your assets and liabilities, and necessarily your assets may not go to those people that you intend to leave behind if you don't have a will. So in the will itself you can leave your exact wishes and the testamentary wishes behind.
People normally think that when you think of a will, you think of a bigger thing like your estate or valuables. What else can you include in a will? And to what extent can a will detail what you really want to do with your belongings? So what all can be included in it?
The estate is a generic word given to assets and liabilities that you hold. So you can include things such as what's going to go on with your property, what's going to go on with your debts. You can also leave certain wishes behind, what you want to be done with your funeral. And if you want to extend the will document itself, you can include things such as trusts, and you can create certain intentions for beneficiaries and leave behind trusts. Now that's an extension of a will document.
Okay, but when a person leaves a wish about the funeral or about their intentions, is that law binding, or is it that it's really only can be treated and valued, honored as a wish?
When you stipulate what you want to do with your assets and liabilities in your will document, subject to the will being drafted in the correct manner and also executed in the correct manner, you can be safely assured that it can be legally binding. Okay. Further subject to there not being any mistakes or errors which cannot be corrected after your death. Okay. The wishes are exactly those. Certain things you can leave a wish behind, but they don't necessarily mean those are legally binding on the executors and trustees that you have.
Yes, your wishes are not. So it is very important how you word your will.
That's correct. So you, in your will document, you will have your wishes on one side, and you will stipulate under a separate heading what you want to be done with your assets and your liabilities.
Okay, so let's just then go on naturally to talk about the legality and the procedure that one should follow to document a will. Can one do it just at their own, or should they go to a person like yourself to draft a will?
It's absolutely not necessary to go to a professional such as a solicitor to draft your will. The main requirements of a will are that you must be over 18 years of age to leave a will behind. You also need to have the mental capacity to leave a will behind, and two people need to witness the signature that you leave on the will, and those two people cannot be the beneficiaries that you name in the will or directly related to those beneficiaries. Those are the main criteria that you need to follow. However, the benefits of going to a professional are that the professional remains independent and the professional can guide you through the process. And it's usually the case, the more complicated estate that you have and the more that you have in your estate, it's advisable to go to a professional who can guide you through the steps on a step-by-step process, and also advise you on the implications of such things as inheritance tax and tax generally.
Which is a huge thing. We'll come to the inheritance tax in a minute, but let's just thrash out everything about the will at the start. So you said above 18, advisable, and all that we say here, I have to every time remind in every legal show, is just information. For anything further, please do take proper legal advice. So having said that, Darshan, you said above 18 is the right time, and you can write a will. Now, generally for a person, what is a good time to start thinking about writing a will?
18 years of age is subject to certain exceptions. 18 years of age is the minimum age that you can leave a valid will behind. Now, in my opinion, a will should be drafted at certain milestones, or reviewed at least at certain milestones, such as the birth of a child or birth of a second child, and so on. Marriage, divorce, if you decide to cohabit. So a will can be left and it should be reviewed at certain milestones in your life.
Okay, and it can be reviewed?
It can be reviewed, that's correct. It can be changed, it can be updated on a continuous basis. As long as you revoke the previous wills that you have left behind, there shouldn't be a problem.
Okay. And does it entail a lot of cost to get to go through a solicitor and review, and where does one keep the will?
It shouldn't cost a lot of money to have a simple will drafted, but again, that's subject to the estate that you have and the complexities that your estate will bring to the table and the advice that you want. A basic will could be as little as a couple of £100, and thereafter a professional, if you're seeking further advice from a professional in terms of trusts or inheritance tax, that will increase the cost. And you can keep the original will yourself in a safe place where it's easily accessible, or you can leave the will with a professional who has access to it, and you can leave certain wishes behind as to what should happen to disclose that will once you've passed away. Now, you can also register the will on a independent third-party community where anyone can go and search whether this person has a will or not.
Oh, I see. You could do that. But that's not mandatory, is it?
That's not mandatory at all. The benefit of that is that there's a clear vessel that holds the will. So if you do pass away, someone can go to that independent third party to see if you have one or not. However, the downside is that you may not want to tell that your loved ones at this stage, while you're alive, that you've left a will behind, and you may want that will to come out following a certain procedure after you've passed away.
Brilliant. Now, if someone has, by whatever design of circumstances, not had a will and passes away, what happens then?
If you don't have a will and you've not stipulated, therefore, what's going to happen with your estate, the law then stipulates what should happen to your assets and your liabilities, and that's called dying intestate, when you've passed away without a will. And the downside of that is that you may not necessarily agree with the distribution that the law will follow under intestacy rules. And to some extent, the intestacy rules that are currently in place don't necessarily cater for the modern type of relationships. For example, if you're cohabiting with someone, your cohabitee will not necessarily benefit directly under intestacy rules, and that doesn't. So it's advisable in that circumstance to perhaps create a will.
So you will be on a back foot. I mean, people you love would be on a back foot if you don't create a will for yourself.
I wouldn't say necessarily back foot, but definitely without creating a will, your wishes may not be aligned to what the intestacy rules say. And in that case, if you want your wishes to be different from what the intestacy rules say, then certainly you'll need to leave a will behind.
Okay. Any tips, any cautions that you might want to say at this stage, something that I haven't asked that you would like to say with regards to will before we go to our next segment?
Sure. The first thing I would say that when executing a will, you must do so in the correct manner, which is that two people should be signing your testamentary document, two independent people, and they cannot be the beneficiaries who you name in the will itself. And secondly, when picking the trustees or executors that you want to handle your estate after you've passed away, do give that some thought, because trustees have a very important job to administer the estate once you've passed away, and that would include going through the probate procedure, dealing with HMRC, dealing with those people you have liabilities with, and you need someone who's firstly capable of doing the job and also who's willing to do the job as well. And it's always advisable to pick more than one.
Have you left anything on will, or that's...
I think we've generally covered
Brilliant.
most of it.
Thank you very, very much, Darshan. We shall now move on to the next episode, but as stipulated, I almost want to write my will now.
Good idea.
You never know what happens, what life brings you next moment. So a good idea to actually write your will, but when you write your will, as he said, to be very careful of not only who is witnessing it, so who's signing up as witness, 2 witnesses you need, but also someone who's a trustee in execution of the will has to be really someone who really trusts and will carry out without feeling the burden of it once you're gone, because that's the key person. So that's what I take the key facts from it. But once the will has been executed, what happens then? That's the section of probate, and also looking at inheritance tax, which is huge in here in the UK, and a lot of confusion there. So please stay tuned on Chai Chat. We'll be back in a moment.